Thank you for joining us. And if you did join this video, then it's because you're interested in estate planning, you have questions, or you wonder if this is something that you should do. We have previously had a general conversation about estate planning. That was our first video. We'll connect it up here. We also talked about and to the young generation, so Gen Z and the millennials, and what they can do in regards to estate planning. That might not always be their first thing on their mind, but it is important that we talked about why it is and what they can do. Now we're talking about Gen Xers, and that is my generation. Think mid-60s to mid-80s, and this is a very special generation because, yes, we are special because we are wedged most likely between two other generations that we are taking care of. To navigate and talk about this rather complex generation and the situation they're in, we have with us 𝘾𝙊𝙉𝙉𝙃 with the Access Law Group, who has so far just guided us through this whole process and explained everything really well. And welcome.
Thanks so much. I'm glad that we've been able to go over so much already, and I'm excited to go over this generation that already has so much on your plate.
Yes, so I touched on the challenges. First of all, they of course want to take care of themselves. They have guardianship potentially. They are guardians for a younger generation. They might have, older kids who have kids. But they also have parents to take care of. So let's just stick with them taking care of themselves. They could be anywhere between 60 and 40 and 60. They're somewhere between 40 and 60. And there is a whole gamut of things because their life, our life, my life, is actually pretty complex. So where do I start if I want to put an estate plan in place? I have a will. Isn't that enough?
That's actually one of the biggest things that we hear a lot of times. And a lot of times when people are approaching the estate planning process, it is just sort of, I guess, almost an afterthought of already have so much going on. I'm already taking care of my family. I don't need to worry as much about doing something after I pass because I'm taking care of them right now. And that's a great thing to have going, to be taking care of your family and to be able to provide for younger children, maybe even grandchildren, parents, that sort of thing. However, having a will in and of itself does not mean the process is going to be easy, and it does not mean that your things are going to go where you want them to go. And so a lot of times when we're looking at this generation, we might be dealing with, again, some children who maybe are still minors, but are probably getting more in the age where, we'd be okay with them inheriting a portion of an estate, but a 21-year-old, 24-year-old might not need everything outright right at once. And so there's some of those conversations of, do we need to put some protections in place? Do we need to put some kind of motivators in there for the children or even grandchildren? And on the flip side, we also might be looking at an individual or a married couple who have accumulated maybe some business assets, maybe some different types of things that are sort of assets in different types of buckets, and we want to make sure that everything is flowing in the direction that it needs to go. And even though a lot of people think and actually say the words, I just need a simple will, or I just need to update my will, it is very rare for someone in this generation to not need anything more than just a simple will or a tiny update to their plan. But we absolutely want to make sure that all of those different things that you already have going on, we can get them all in one place and organize things so that you're not feeling overwhelmed. We've already taken care of it.
And we already touched on the different parts of the estate planning that also apply, of course, to this generation, which is the guardianship, taking care of whoever needs taken care of, assets, and again, personal directives. And you just touched on the guardianship, making sure that everything is in place, whether it's monetary, that funds are, distributed appropriately, but also assets. I mean, we want to have our assets protected. We want them to go to who should have them. And okay, maybe that's a very personal thing, but I definitely don't want my funds, my hard work earned money, to go to courts, to go to taxes that were maybe not necessary, had I planned ahead of time. To me, that's a huge thing. And then, of course, the health directives. At this point, I'm just thinking, well, I need to make sure that my assets are going to be distributed appropriately, and I don't want to pay anybody fees, and taxes.
And actually, one of the biggest situations in this generation that we run into is if someone is married, if we're dealing with spouses, they may just think, I don't have to worry about this because if something happens to me, my spouse will take care of the whole situation. That's not necessarily a good perspective to have, because the spouse is already going to be dealing with a lot if one spouse passes or becomes incapacitated. And just with the way the law is set up, if we're dealing with a blended family, if we're dealing with maybe some competing interests from other family members, it can be a lot of work to not have things set already and cost exactly what you said: additional court fees, time, stress on everyone. One situation that we actually had here was a couple who was married. The one spouse had an injury, became incapacitated, couldn't make her own decisions. They didn't have powers of attorney in place, so the other spouse, the spouse that was still having the ability to make decisions, taking care of everything, had to go to a court and say, I need to be appointed as guardian and conservator over my spouse, which not a lot of people know. Just because you're married doesn't mean that you can legally take care of everything for your spouse. So because of that, this spouse had to take time, money, effort to doing this whole guardianship, conservatorship hearing. Then the spouse who had become incapacitated actually made an amazing recovery, and that person was totally able to make their own decisions, still had to go back to a court and prove, now I do have the capacity to do this. We need to get rid of this guardianship and conservatorship. So it's one of those things that can cause so much stress, so much time and energy and money costs, that getting these things set up and then potentially modifying them, but just making sure they're set so that we avoid those things, is vital to this process.
Yeah, and I'm just thinking of a couple other instances that I have run into, not necessarily just in relationship to real estate, but just overall. You have a situation with, lots of blended families nowadays, which is great. But that can also cause some friction. So we had a situation where, the spouse didn't want, the other spouse's kids to get this or that, and to really protect that. That was really important to this person, and they made sure with the trust that all that was taken care of. That actually kind of kicked off my thought of, not that I have that problem, but I'm like, oh my gosh, what a mess this can be. I think we really need to get this figured out. And, I came with basically a 30-year-old will to you. So, which I don't think I'm even the exception.
Well, and it's funny because we see people from across all age groups have all or nothing. Sometimes people in this age group sometimes are coming to us with, we did something a while ago and are realizing we need to update it. Sometimes it's a simple update, sometimes it's a whole overhaul, but that's kind of, I think, fairly common. But it's just as common for people to walk in and say, we've never even thought about this, but we know that we need it. I actually had one client who came in who was in his 90s who had never done any of this. And that's not recommended because you're sort of pushing the envelope a bit at that point. But this generation, I think, is a prime example of when we're really seeing things across the board of nothing to having everything set or having something in between. And it's also a great time to sort of get things more set in stone, sort of say everything that we need so that the whole plan can come together and be specific enough to do exactly what you're wanting it to do.
So in a world of, global travel and just interconnectedness, do I need separate estate planning when I have assets in different states?
So the good news is, in most situations, for instance, if we're creating a trust here in Colorado, we can include everything that we need to in that trust that was made in Colorado. Trusts are actually very flexible, where if you create one in one state, move to another state, and all your assets are in the other state, you can do a pretty easy amendment when we're looking at a revocable living trust to update it according to that state's laws. And so even if, we have some rental properties in another state, or we have maybe some other vacation homes, a lot of clients that are here in Colorado sometimes don't like to spend the whole cold winter in Colorado. So I've had a lot of clients who, maybe have just a little living space in a warmer state, and we can absolutely incorporate everything into one estate plan so you're not doing different things in different areas.
Okay, so and do you have to have a separate trust for accounts versus real estate? So, like retirement funds, any kind of investment funds?
Right, that's a good question, and that's something that our trusts are always going to address, the different types of assets that the trust can be involved with or receive, as well as designating anything that is in the name of the trust, like real property, houses, land, where it's going to go. So we don't need separate trusts for separate types of assets. We can have everything essentially flow into one trust and be distributed according to its terms. And that's, I think, the default, what we like to see, because it's easier on everybody. It's easier on the individual creating the trust, those people deciding where their assets are going to go, and it's easier for the trustee who's managing things after everybody passes away. However, there are some situations where it might make sense to have some different tools to accomplish different, more complex goals. So that's one of the big reasons why in this generation, even if you have an estate plan, it's worth looking at it every 3 to 5 years to make sure the goals are being accomplished. And it's also a good idea to, even if you've never approached this process, to get in touch with an attorney who can get it going for you.
Okay, but if I have a trust in place, then I lose all the ability to kind of direct the trust myself, because another trustee is doing everything, right?
That's actually a pretty common misconception, and it's sort of I think the culture of trusts and estate planning has shifted over the past couple of decades, where it used to be the trusts we were looking at were very rigid, were only being used for really complex situations and dealing with different tax implications. But nowadays, with the way the law has shifted and the way most people's assets and estates have shifted, we usually are approaching this process through a revocable living trust. And this is a trust that, say, me and my spouse, we are creating this. We still have full say in what's in the trust, what's out of the trust. Say I put my home into the trust and then I decide to sell it, totally fine. I can buy a new one in the name of the trust. It's really a very, I think, kind of fluid tool that we use while we're both still living. Then once we both pass, at that point, successor trustee steps in and takes over and has to abide by what we've put in there. So revocable living trusts are very flexible and very effective at accomplishing your goals while also giving you the ability to do whatever you want and whatever you need to while you're still living.
Okay. This might be an odd question, but who should I designate as is it also an executor with the trust? No.
There's a lot of different terms depending on who's doing what. Usually executor or personal representative, we're looking at a will and looking at the probate process. Mm-hmm. For a trust, we're usually looking at a trustee
Okay.
Sometimes there can be co-trustees or substitute trustees, but the trustee is the person who's in charge of what's in the trust. And that person can be really anyone that you want as long as they are 21 years old.
And they know about it.
Right. Yeah, they need to know that they're being appointed as a trustee. That's a kind of a prerequisite. But we encourage people to really think that through, because some people, if you have a really big, complex estate and you're wanting to do a lot of different things with the trust, maybe looking at a professional trustee might be worth some consideration. I usually encourage my clients to think of someone who is close to them, who they know, and who they trust to make the decisions according to the trust, because it helps to have someone who's familiar with your estate and familiar with your wishes. It's going to be more likely that that person is accomplishing everything you would want them to when they know you and they're someone that you trust and can explain these things to throughout your life.
Okay. Now, moving to, let's call them personal directives. So we touched in the first generation already on the healthcare, the health directives, and they seem much simpler there, because when you're getting older, of course, you have those who can make any kind of decisions, or the decisions that you want for yourself, and but also long-term care issues. So for example, of course, we have long-term care insurance, but I am referencing more protection from maybe government Medicaid being able to, reach into your pocket after you passed away to recuperate some of the money.
That's sort of, I think, becoming more and more of a forefront consideration for people in this age group, because potentially people in this age group are dealing with that with their own parents or grandparents even. And I know there's a lot of competing interests and competing voices on how much Medicaid can take or what they should and shouldn't be able to recover. So whenever we're looking at that, there are a lot of different techniques that we can get into, but that is one of those very specific to your situation considerations that we look at. But some of the basics there, if we're looking at Medicaid or some other benefits program, we want to make sure that we're addressing it in the proper way. So if we're looking at a situation where someone has a disability or there's special needs, we might look at a special needs trust to make sure Medicaid can't come in and take any of that. If we're looking at long-term care where somebody didn't have long-term care insurance and Medicaid is trying to recover an estate, there are some exceptions to how they can and can't recover. If they can put a lien on a house, or if they are not able to get any hands on the house. So those are the things that right off the bat, I'm going to tell someone probably you should make sure that you've talked to a specific Medicaid planner who knows those details before we're getting something set. But we're also going to be able to set things up so that we're addressing the issues. We're considering, Medicaid has a 5-year look back period. We're not trying to do something that's going to cause an issue, while also getting things planned out so that we're not running into those issues without having already addressed them.
Okay, so if somebody is ready to move forward with just a consultation, I wanted to point out that you offer a 45-minute free of charge consultation just for people to understand what it is they need and where they need to go, and then you can tell them exactly what would cover them, their assets, and basically their life. And and all they have to do is then just go to your website or give you a call.
Yep, absolutely. We make it as easy as possible where you can give us a call, get scheduled, or even go directly on our website, and we have some links to do that there. And we really want to make sure we can take a hands-on approach, take the stress off of you, and get this thing addressed so that it's one less thing on that plate so you can actually go and do all the important things that you want to do.
All right. Well, thank you. And if you are a Gen X, uh, in and if you are in this Gen X generation and you have questions about what Gen Z needs to know, then check out our other video. Take a look at our first video where we just talked in general about estate planning, and we're looking forward to seeing you in our next video, because you as Gen X, you definitely need to see that.